AI and Data Show. For the latest updates in AI, with host Matthew Holman and special guests Phil Bilney and Ben Mailing.
We are going to start our great debate on all things copyright and AI, and I'm going to hand over to Phil Bilney. Phil.
Thank you, Matt, and thank you very much for letting me take control of this next segment. So, in this next segment, we'll be discussing, as Matt suggests, all things AI and copyright, and in particular, how do you protect creative rights whilst also permitting AI data mining and training? Can these interests ever be reconciled? But before we dive into our discussion and debate, I thought it best if we take a step back and set the scene and just understand a bit of background as to why this is so topical. So what's all the fuss about? Well, the rapid rise and development of AI in recent years has led to a heated debate over whether UK copyright framework is still fit for purpose. And one of the main reasons for that, and one of the main issues sort of raised by AI, is around the training of AI models. That is because AI models generally require a huge amount of data to train on, which often involves the copying of copyright works. Copying works to train AI models requires a license from the relevant rights holder unless an exception applies. So a number of concerns are being raised around AI and its applicability to copyright. I put up there on the slide a few of those. The UK government are very much alive to these issues, and shortly before Christmas released or published a consultation, and the UK IPO consultation entitled AI and Copyright. This was published on 17th December 2024, and on the link you'll see a link to that copyright, to that consultation. Now the consultation looked at a number of key topics, including proposing a new text and data mining exception, which we'll come to in a moment, licensing, so looking at the current licensing frameworks and whether they are fit for purpose, and does it allow copyright holders to license their work to AI providers to use that for training purposes. Transparency, so how transparent should AI providers be over the copyright works they use to train their AI? Computer-generated works, it also looks at that and asks questions around whether the concept of computer-generated works is still relevant. And also it looks at AI outputs. So how should those be dealt with and labelled? Now then, the UK IPO consultation is still very much live and ongoing, and the deadline for responses is the 25th of February 2025. So if you haven't had a chance to look at it or would like to respond on some of those topics and answer some of the questions raised by the UK IPO, please do go and have a look at it. There is still time to put your responses in. So let's have a look at the TDM exceptions that have been sort of mooted and proposed by the UK IPO. Now then, the UK IPO looked at a variety of options. The first option, I should say, the numbering has been taken from the UK IPO consultation itself. Option 0 is to do nothing, so preserve the status quo. Option 1 is to strengthen copyright, requiring licensing in all cases. And then, of course, they then looked at another option, which is the opposite end of the spectrum, which is, let's have a broad data mining exception. They then also looked at option 3, or considered option 3, which is almost a halfway house, which is that a data mining exception which allows rights holders to reserve their rights, underpinned by supporting measures on transparency. Now then, of those options, the UK IPO favours option 3. So that was just a brief interlude into the background to today's discussion. So let's get on with the great debate. And to help me explore the text and data mining options and related matters, I'm joined by my colleague Matt Holman from Crips, who needs no introduction, and also Ben Mailing from EIP. Ben is a UK and European patent attorney at EIP, specialising in AI. He also leads a multidisciplinary team of lawyers at EIP called Codify, who advise on all aspects of IP in software, data, and AI. So welcome, Ben, and welcome, Matt. I should start also by saying that for the purposes of today's debate, Matt is going to take the side, I guess, or the slight side of AI developers, and Ben is going to look at it more from sort of the creative point of view. Right, well, let's get straight into it. So as I mentioned not so long ago, the government clearly favours a TDM exception along the lines of option 3, so an opt-out for rights holders. So Matt, do you think AI developers should be pleased by the current direction of travel?
Well, let me start by saying that I'm arguing the case of my hypothetical client, which is all AI developers, but it's not my personal view. This is just a view of my client that I am promulgating, and Ben equally is in the same boat for creatives. Is the TDM exception the right thing? I don't think so. It's a good halfway house, I suppose. It's the lesser of two evils, but make no assumption about it. The TDM is not a great way to go. It's flawed conceptually. It's flawed theoretically. It'll be flawed pragmatically in its outworking. And from the perspective of AI developers, we need something. And if the UK government is going to give us something in the form of a TDM exception, then we'll take it. But it's not exactly Santa coming for Christmas.
Right, so clearly it's not necessarily the best thing yet. And Ben, what about your point of view if you were arguing from the side of creatives?
Sure. So I would start by saying the creative industries should not and overwhelmingly do not support the weakening of their ability to protect creative works against use by generative AI companies, without permission or compensation, many of whom will then go on to create products or services which can compete in the market with those works. And we should be clear that we are talking about a weakening of rights here. I think with a certain amount of kind of psychological anchoring and some red herrings around legal uncertainty, the IPO consultation sort of presents the option 3, the TDM exception with opt-out, as a balanced kind of compromise. But in reality, I think it really, in the short term, tips the balance massively in favor of data scraping AI companies. And that's mainly because there's no workable rights reservation mechanism. So effectively, it is going to be just like a broad TDM exception without opt-out. And also the very notion of requiring someone to actively reserve their rights goes against the sort of well-established gold standard principles of copyright. I think in the long term, it's also bad for the AI industry.
Thank you, Ben. So again, similarly, from your point of view, not necessarily is the TDM exception proposed, not necessarily the silver bullet that we're all looking for. So let's look actually at the sort of economic arguments behind this exception, as often it does come down to money. Ben, this exception that clearly the UK IPO are looking or favouring, do you think it's good or bad for the UK economy?
So I think we should start with just talking about some cold hard numbers here. I mean, the government's own figure suggests that AI could contribute 47 billion annually to the economy over the next decade, which is impressive. But it shouldn't be forgotten that the UK's creative industry contributes 126 billion to the economy. And in the absence of any economic impact assessment, which, by the way, shockingly hasn't taken place, it's not clear to me that the potential harms that could be done to the creative sector and neighbouring sectors as well, things like journalism and so on, publishing, would be adequately compensated by the sort of speculative benefit that would come from enabling free access to data by AI companies. I'd also just like to say that the UK, it's responsible for contributing a disproportionately high volume of top quality top quality data for training AI systems. That can be, you can objectively show this using certain data theoretical algorithms, which we're going to hear about more in the coming months. But that is one place where the UK truly is leading. Quality of data is, one of the strongest drivers of performance in these models. And I think because it's somewhere where the UK is a leader, we should be looking for ways to leverage that. And we shouldn't be, throwing those valuable assets away to facilitate what is essentially the biggest cultural and economic land grab that's ever been attempted by big tech.
Well, look, I'm going to come straight back in on that. We're going to do some objecting on behalf of AI developers because, you could argue that a lot of the points being made are actually, from an AI developer perspective, they are the justification in some respects. If economic growth is going to be so dramatic and so impressive and so revolutionizing to the United Kingdom and other countries, then why would we want to stop that? Why would we want to stand in the way of it? One could argue that creators are essentially subverting the next big disruptive tech event of humanity. What we want to see is freedom for this to happen. It's the greater good argument. Some numbers to throw around. The UK government has also suggested that by 2030, the UK economy would have had 400 billion added to it on account of AI. We also know from the opportunities plan that the UK government is planning to develop many data centres and AI growth zones that are going to have a huge effect, not just on the people working in those sectors in that part of the country. We know Liverpool and other places are shortlisted, but all the other things that will fall out from it. So, let's throw some other numbers around as well. I do understand that the creative sector is rubbed up the wrong way a little bit by some of this stuff, but it's worth pointing out that 2.4 million people are employed in the creative sector, yes, but there are actually 33.4 million people in the workforce. It's quite a slender number of the overall affected population. Not suggesting that every single one of them would be affected, Phil.
Thank you, Matt. Clearly, yeah, so some differing views there. And it's debatable whether, it's going to have the economic impacts that we'd like. So in terms of how do we resolve these sort of issues, clearly, other countries and territories have been looking at this, and they've been going and doing their own thing. Is it worth us looking at other jurisdictions, and are there any out there that we think have got it exactly right, and we should just follow their model? Ben, I'll come to you on that first.
So on the question of whether we should be looking at other jurisdictions, I think it's very clear that the government is peering over the fence at the EU and what they have done. I think that seems to be the blueprint for their preferred option. I mean, so a bit of background: the EU's CDSM directive, which was introduced, came into force in 2019, introduced a text and data mining exception with opt-out, very similar to the one that's being proposed at the moment. And that was kind of to enable the kinds of data analysis and insights to be drawn from large quantities of data using the kinds of AI model that existed those days, which was primarily discriminative, predictive models. Generative AI had not really come onto the radar at that point, and certainly not onto the radar of EU bureaucrats. The AI Act, however, then went on, which to seemingly confirm that the TDM exception does apply to generative AI models. There's some debate as to whether it should or not, but that seems to be the case. And the generative AI, the provisions on generative AI will come into force in August this year. But what we can see is that from the way that generative AI companies have reacted so far to the TDM exception and opt-outs have been widely ignored. There's been no standardization of the rights reservation mechanism, and it's really not clear that there is even a plausible way to do this. I mean, you can talk about various different methods. You could talk about website level metadata, page level metadata, even, individual images could have a bit of metadata saying, please don't scrape me. But all of those, there are problems with all of those. You either have to have control of the web server, you have to be sure that the metadata is not going to be stripped off during some sort of technological process, which happens all the time on the internet. And in fact, it's been such a failure, the opt-out provision of the TDM exception, that the EU is now newly consulting on a centralised rights reservation repository, which I think is also going to be a disaster. But again, it kind of flips the burden onto rights holders in a way that shouldn't really happen with copyright. So I would say that we shouldn't be looking at the EU.
Yeah. I was going to say, I think you're right in terms of the UK IPO consultation absolutely is looking strongly towards the EU route, and that being the way forward. Matt, what do you say to that? Do you think we should be following the EU's
Well, the EU model is better than the current UK model because the current UK model is highly restrictive. It almost certainly requires licensing. There's some interesting academic arguments orbiting around the outer reaches of it, but really, I think we all know that it does. That's going to impact growth. It's going to impact development. So we don't like that from an AI developer perspective. But is the TDM the way to go? I mean, looking at the TDM in Europe from the UK perspective and saying, "Oh, I want that," is a bit like looking at your neighbour's rusty car and saying, "Oh, do you think I might go and get one of those?" Another example is the US. The US has fair use, and anyone who's studied this sector will know that there's a very different copyright regime in the US. You can, for example, copyright is registrable. There's a whole different governance structure around it, and the fair use is like the epiphany of common law jurisdiction, where actually it's dealt with in the courts. It's dealt with by litigation. You go to court and you say, "Hey, I've decided to use something, and I think it's fair use." And the court in that moment can look at it and say, "Do you know what? We agree that is fair use in this moment, in that use case, but not in all moments for all the use cases." That's not how fair use works. It can apply to, well, it was sort of designed for use in editorial comment, research, statistical analysis, but it can also occasionally be used for commercial purposes as well. The piece de resistance case for this is absolutely New York Times versus OpenAI, which is a case that is going through the courts in the States. There was a equivalent of a summary judgment hearing there in the New York federal court in January. I think we're still waiting to find out what happened there. This one will almost certainly go to trial. Everyone's watching and waiting to see what happens with that. The argument basically is OpenAI saying, "Hey, our universal scraping of New York Times journalistic content, that's fair use." We'll wait and see what the court's got to say about that.
Thank you, Matt. I think from what both of you are saying is that, other jurisdictions are definitely trying different things, but it sounds like not one of them has necessarily nailed it down. And so, this tension between rights holders and AI providers is only going to sort of increase as things progress. If you could come up with any solution or try and resolve this sort of tension, what do you think? What do you think that should look like in an ideal world? I appreciate that's a tricky question.
Well, it's the $1 trillion question, I would say. And I don't have all the answers here, but I would say that, just to re-emphasize what we've already said, I don't think we should be kind of looking at the if the UK really truly aspires to be a leader in AI, we shouldn't be looking at the EU and looking to follow what they're doing, particularly as it's highly flawed, as I think we're almost all accepting. I think the UK government should be far more creative and be far more forward-looking about this and do something that's truly novel. I think that there should be some sort of public service introduced, which is to facilitate the licensing en masse of works, copyright works to AI companies. It could be in the form of some sort of data trust. I think that this would allow for the kind of flexibility that we really need. The TDM exception is too blunt. I mean, it may be that some rights holders would allow the use by generative AI companies which are going to go and do something, in a neighboring field or something, which is kind of analytical, not creative. But they might not want their music scraped for an AI music generator. And I think that kind of flexibility has to be built in somehow. And I think that this kind of licensing scheme supported by government would be a way to do that.
And that was that. What about you? What are your views on perhaps the ideal solution? I know sort of previously we discussed that any solution seems predicated on a bit of tech that doesn't yet exist. So, what are your thoughts?
Well, look, I'll be really quick in my closing submission to the court of the viewer. But a lot of the suggestions a lot of the things in the consultation do suggest that there's going to be this Harry Potter magic wand moment where some tech that doesn't exist comes along and makes it all work. That is one of the many flawed parts of this. From a developer perspective, hey, look, we will take TDM, not because we like it, but because it's better than what we have. Do we could we come up with something better? Yes, we probably could, to Ben's point. The ultimate version of this, I think, from a developer perspective, is just option 2 in the consultation. It's a broad license, as much data as we can possibly get our hands on for the maximum amount of possible training to develop the most AI models. That's the closing argument for the AI developer case.
Matt, Ben, thank you very much. Thank you for your insights on those points.
Thank you very much, Phil. That is the end of the show. And it leaves me to thank all of you for joining.